Good morning, Mr. Notice McConaughey.
Good morning. So please the court, Edward Notice McConaughey here for Kevin O'Brien, the plaintiff at the trial court, and the successful party at the trial court by way of a jury verdict. This case is about the standard of review on appeal from a jury verdict. When reviewed here by that standard, the jury's verdict in this case must be upheld. The standard is whether anywhere in the evidence any combination of circumstances can be found which would support reasonable inference in favor of the jury's verdict for Mr. O'Brien. When viewed by this standard, the judgment for Mr. O'Brien must be upheld. This is a case involving a jury's determination of a breach of fiduciary duty. This was evidence of the ultimate effort to freeze out a minority shareholder and the ultimate facts supporting a finding of breach of fiduciary duty. And I say that because, first and foremost, the majority shareholders denied that Mr. O'Brien was a shareholder at all. They attempted to freeze him out as a shareholder, and they did that in connection with corporate meetings and corporate minutes, and at trial, they denied that he was a 48% shareholder at all. The brief that has been submitted on behalf of Mr. Pearson...
Can I interrupt you for a minute?
Yes.
I thought there were some minutes, corporate minutes, that reflected that he was a 48% shareholder.
Yes, Your Honor, and that's precisely one of my points, which is when the whole issue about the two-thirds vote for selling the only corporate asset came up, there was a meeting. It was a director's meeting and a shareholders' meeting. Mr. O'Brien attended that meeting, and Mr. Pearson and Mr. Palm produced proposed minutes of a shareholders' meeting. Those minutes showed him as a 48% shareholder. No actual meeting took place, and no vote took place, and those minutes were never signed. However, at trial, they denied that he was a 48% shareholder. This was all placed in front of the jury.
Did they deny the existence of those proposed minutes?
They did not, Your Honor. And it is our view, and I suggest that the jury, having received the draft minutes showing that he was a 48% shareholder, those minutes having been prepared by Mr. Pearson and Mr. Palm, and then for them at trial to take the stand and testify that he was not a shareholder, and for his counsel to take the position that he was not a shareholder, was evidence of their frame of mind and the way they were treating Mr. O'Brien. On the one hand, when it was convenient for them, they would take the position he was a shareholder. At trial, when it became obvious there was a dispute, they denied he was a shareholder.
Mr. Notice McConaughey, forgive me, could I ask you this question? In its decision, the appeals court characterizes the breach of fiduciary duty, the breach, as the refusal of the defendants, quote, to press forward with an acquisition. Now, clearly, the letter agreement committed them to certain things, provided that it was economically feasible. So what precisely did they not do that constitutes a breach of fiduciary duty?
Your Honor, the appeals court did make that specific finding.
No, they're just characterizing your argument at that point.
Right.
So when you say to me, this is what they didn't do.
Okay. What they didn't do was, first, they didn't agree that Mr. O'Brien was a 48% shareholder. They didn't agree that he was entitled to 48% of the proceeds of the sale of the note. They didn't provide him with financial information concerning the corporation. They didn't give him his right to oppose and prevent the sale of the only corporate asset under Section 75 of 156B, and they didn't honor the original agreement of the parties with regard to why this company was set up in the first place.
And in what respect did they not honor the original agreement?
All the parties agreed that the purpose for this corporation to be set up was to obtain the note, which they did do, and to use it as leverage to gain control over the development and to develop the property.
Good.
All parties agreed to that. There was extensive testimony to that effect below. And that ties in, Your Honor, with the fundamental finding of the Wilkes versus Springside Nursing Home case, which is that the test of a breach of fiduciary duty.
No, I know what the tests are. I'm just asking you what they didn't do.
What they didn't do, Your Honor, was they purchased the note and the mortgage,
Yeah.
which we...
I know what they did.
Yes, okay. What they didn't do then was to go back to the Shelseys and insist to the Shelseys, we have the note, we control those 9 lots, you have to deal with us, and you have to make an arrangement with us for the sale of this property, and these are the terms on which we will do it.
I thought they did do that. I thought
They didn't.
I thought they made an overture and said, we will forgive the debt, you pay us $250,000. Am I correct? They had one round of negotiations?
They did not, Your Honor. The evidence was that they went out and hired a consultant who
Right.
approached the Shelseys, and that he never actually made an offer to purchase the property. The evidence was, from Mr. Kahn, the consultant, that he had left the Shelseys with the impression on purpose that Pearson and Palm, that this company was not really interested in purchasing the property.
Isn't that the whole point here? That at that point he somewhat discouraged the Shelseys from thinking that they were interested in purchasing this property?
Yes. The evidence, Your Honor, is that essentially as soon as they engaged in this venture, Pearson and Palm abandoned the purpose and never really made any kind of a good faith effort to follow through to negotiate with the Shelseys to purchase this property.
So you're saying to me that if I look at the evidence, there was no negotiation, there was no offer, there was no saying, we want to buy, give me your best offer, or we want to buy on these terms?
Correct, Your Honor. That is the case. And in fact, the consultant was never informed about the letter agreement between Mr. O'Brien and Pearson and Palm, did not know Mr. O'Brien was involved in the entire transaction, and was not given instruction by Pearson and Palm to go and attempt to purchase, to use this note and mortgage, to attempt to leverage it into control and ownership of that
What
parcel.
did he think he was doing?
He was looking for the best outcome that he could get for this company with the note and mortgage. He talked about avoiding risk. He talked about getting what he considered to be the best result from them from the note and mortgage, and concluded early on that using it to get a purchase price for the note and mortgage was the best outcome for Pearson and Palm, and that's what he pursued. So that is the testimony, and, Your Honor, and the jury could well have believed it.
Was there any evidence, Mr. Notice McConaughey, that your client, Mr. O'Brien, had he not reached an agreement with Pearson and Palm, that he would have sought out other financing opportunities?
That did not come up, Your Honor,
Okay.
and the reason was that Mr. O'Brien testified that he had a prior relationship with Mr. Pearson, and when he had the opportunity, he took it directly to Mr. Pearson.
So he went to him first.
Yes.
The facts, just for clarity, the facts are that when the consultant interacted with the, I guess their name is Schultzes or
Shelsey.
Shelseys, and gave them the impression that they were not interested in purchasing, they turned to another group who did purchase.
Correct.
Can I ask you a question about damages? I take it your theory of damages was lost profits.
Correct, Your Honor.
And how do you get over the White Spot Construction Company versus Jet Spray? It seems to me that the profits here are very speculative.
Yeah. Several things, Your Honor. One is that there was a specific instruction by the judge to the jury, and that specific instruction told the jury that they could award the plaintiff his proportionate share of any lost business profits that he had proved with reasonable certainty or that was caused by the breach. That instruction to the jury was not objected to. The jury was told that they could consider lost business profits without objection. Then you go to the next step, Your Honor, and say, was there a reasonable nexus between these damages and the actions of the defendants? There was extensive, very practical testimony from a number of witnesses at trial, including Mr. O'Brien, using the defendant's own projections and expert testimony as well, which supported a finding by the jury that it was quite reasonable that they could have used this note and mortgage to obtain control over this property, that they could have built the roads and built out these houses. And there was, in fact, testimony from the party who did purchase the property that all of those steps were taken. So I think, Your Honor, there was...
In white spray, I mean, the court really seems to suggest there are all kinds of damages you might be able to collect, but when it comes to lost profits, it can't be just some general sense that there's probably a lot of money involved, but it has to be a very specific accounting of how those profits and certainty with respect to those profits. And in jet spray, in fact, the contract was for the person to build something and get, for estimates between 140 and 160,000, and would get 10% of that as a profit. And the court said the evidence wasn't sufficient that someone else came in and built it for 161,000 because maybe it was a different building, a different type of building. I mean, how do we know what kind of houses would have been built here? How do we know any of that with any certainty at all?
Well, Your Honor, what we do have here are projections that were prepared by the defendants themselves in anticipation of all of this. And those projections were presented to the jury in a very concrete way, and it had in there their decisions with regard to the size of the houses that would built, the kind of houses, what they would cost. And so it was the defendant's own testimony about what they expected realistically could be done with this property.
Well, I know that in this case, same case, they projected at a certain cost, and therefore their profits, let's say they projected it at 150,000, their profits would have been 15,000. Someone else came in and built it for 161,000, and the court said, well, that's just not specific enough. I mean, how do you get around this? Does this just not apply to this case, white spray, white spot?
Your Honor, our case was a jury case. I don't frankly remember whether or not that was a jury determination. Our case not only had the defendant's own projections, it had Mr. O'Brien's own testimony, and I will point out, Your Honor, that Mr. O'Brien himself testified to all of the information about the lost profits without any objection whatsoever from the defendants.
I think that would have made how much money based on how many homes to be developed?
Correct.
How many homes were there to be developed?
60?
60 were 60 lots, Your Honor. I believe that's right. So he went through and determined it, and again, there was no objection to that testimony going before the jury. Then to make sure that we were giving the jury...
And no objection to the instruction.
Correct. Then to make sure that we were on solid ground, Your Honor, we had an expert come in, and that expert took standard estimating procedures to determine what the lost profits would be, what the costs would be. And we submitted that testimony to the jury. Then there was actual testimony, some of it brought in by the defendants, about what actually happened at the property. And all of that was, so there were 3 or 4 different ways.
Did they object to that testimony?
In terms of the expert, Your Honor?
No, in terms of what actually happened.
No, actually, they didn't. They actually brought in the person who purchased the property, who testified to the cost of the roads. So that was, in fact, brought in by them, Your Honor. I believe they did testify to whether or not they did object and argue that the figures were speculative as to the building of the houses.
Yeah.
But some of it was brought in by their own witnesses. This court decided the Brody case just in December in terms of the breach of fiduciary duty and damages. That was a case that had to do with remedy. As I went back through that Brody case, the evidence there that supported the breach of fiduciary duty and the finding of breach of fiduciary duty was far less compelling than the testimony we have here and the evidence we have here. There, it was a refusal to share financial information of the company. We have refusal to provide financial information, refusal to hold corporate meetings, refusal to allow Mr. O'Brien to participate in meetings with the Shelseys, the sale of the primary and only asset of this corporation in violation of 156B, Section 75. We have the denial of the fact that he's a shareholder, and we have the fact that they didn't honor this agreement. So all of these would be something the jury could consider from which sufficient inferences could be drawn in favor of this verdict, and I would ask the court to uphold the jury's verdict and the judgment entered by the trial court.
Thank you, Mr.
Thank you very
Notice
much.
McConaty. Mr. King?
Thank you, Your Honor. Your Honors, may it please the Court. This case involved two errors of law that could be addressed on the appeal level, and one of them was addressed below at the appeals court level. The verdict cannot stand as it ignores established law in two areas. One, you've heard on both of them today, first one being the fiduciary duty area and the second one being in the area of damages. There's a long line of decisional law in both areas, which we'll touch on. Of course, it's covered in the briefs. Bottom line is both are questions of law and are ripe for decision on appeal to overturn the verdict. Either one alone is sufficient to overturn the verdict. As I noted, the appeals court stopped at the breach of fiduciary duty level, and in the decision basically encapsulates the outcome here by saying that there is no law out there, no support out there in the fiduciary duty law that would support a finding of a breach where there was no self-dealing, no fraud, no disproportionate treatment that disadvantaged the minority shareholder or treated the minority shareholder.
Mr. King,
yes.
here's my problem. There's no question as to what the intent here was. In other words, it wasn't as if these were three college roommates who decided to set up a small corporation to go, make some software. Here you have Mr. O'Brien going to some people and saying, I have an opportunity for us to get this to develop the property, correct?
Yes, Your Honor.
The piece of the appeals court argument that seemed to me to raise questions was what was brought out by the answer to my question by Mr. Notice McConaty, which is there was no offer made to purchase it, nor did they ask the Shelseys what they would take, correct?
Your Honor, I do not know exactly what the evidence below was as to whether or not.
Well, you should know what the evidence.
Let me explain. There is, I believe, conflicting testimony as to exactly what
yes, and
the
that's
consultant.
That's for the jury to decide.
Correct.
So, what the appeals court says, the argument appears to be the defendants could have made the Shelseys an offer that was reasonable to both sides. I don't think that that's what the claim is. The claim is you said that we would enter into a closely held corporation in order to buy the property. You then do nothing. You hire a consultant, and you say to the consultant, get me the most money on this note. That is not what the plaintiff said. That was not the purpose of the corporation. He didn't agree to that. He wasn't consulted about that. What he wanted to do was to attempt, using the note, to get the right to develop the property. Not unreasonable, because that was his business, correct?
Correct, Your Honor.
I mean, he's not in the business of buying up overdue notes and trying to get the most amount of money on them. He's in the business of using a financial instrument to leverage his ability to get a property.
Who are you talking about, Your Honor? You're talking about Mr. O'Brien? I don't believe there's any evidence that that's his business model. I believe he's in the
No, not
business
his
of
business
developing.
model, but that's clear what they said.
Clearly, the original goal of this enterprise
Correct.
was to acquire the entirety of all parcels.
And your clients did nothing to further that goal without consulting him.
That is not correct, Your Honor. The first thing they did to further the goal was to spend their own cash, $100,000, to acquire a note.
Yes, that was part of the agreement.
Okay, and that note might have become uncollectible and worth less than $100. So
It
right
might
away,
have. It might have. And the purpose was to use that as leverage to get access
Correct.
to what they all agreed was a worthwhile prospect to pursue, correct?
Yes, Your Honor. And in going forward with that plan, they are entitled, where there was no contractual obligation that they actually go through with the acquisition. In fact, there could not be one
This is not because, as long as it's reasonable. But they had an obligation they undertook to attempt to acquire the property, not for some unreasonable price, or to consult with the minority shareholder about changing the objectives.
Correct, Your Honor. And it is our position that in the exercise of their good business judgment, they did approach the Shelseys through their consultant. They did approach and try to figure out, gauge the situation, and figure out what was the best time to make a move. Unfortunately, Premier arrives and makes an offer.
Did they ever go and say, we'll make a better offer?
I think it was apparent to the Shelseys, I'm confident it was apparent to the Shelseys, and the evidence which support that Pearson, Palm, and Summerhill Enterprise with Mr. O'Brien were a potential buyer of the entire area. The entire
Did they say
parcel.
so?
Excuse me?
Did they so testify?
The record, as I said, is I think, foggy on exactly what Mr. Kahn said to the Shelseys. It is clear that at one point he says, well, would you buy the note back? Okay,
Would you buy the note back is different. But I asked Mr. Notice McCarthy, and he said they never made an offer to purchase the property, and they never said, make us an offer. If you want to, now you can change your mind and decide, your consultant says, hey, this is a good opportunity to make a quick 300%. You can do that if you go to your minority shareholder and say, do you have any objection to this? This is a quick turnaround. Let's go look for some other properties. That's fine.
Your Honor, there was no requirement that they rush out the day they bought this note and make an offer. There was no schedule set. There was no plan of attack that was agreed upon. Instead, the decision was, using good business judgment, this is a negotiation. They're not going to go out and say, we want it so badly, here's $5 million. No, this is a negotiation. It has to be timed properly. You gauge the players, and you wait for the right time to strike with your offer. Their good business judgment was, let's sit back and see how this plays out. Unfortunately, Premier came in.
Isn't that viewing the evidence in the light most favorable to you?
No, Your Honor. I believe that's the reality. In fact, Mr. O'Brien testified that they did nothing for a while.
Well, didn't the consultant indicate they weren't interested in purchasing?
That's the testimony from Mr. O'Brien. That's in the light most favorable to Mr. O'Brien, yes. And that was our position, is that was a negotiation tactic. Now, if that's the case, you will note at the end of the day, the agreement they did sign.
Well, let me just stop you there. Don't we have to look at it in the light most favorable to Mr. O'Brien?
Sure you do.
And so, from his perspective, the consultant indicated they were not interested in purchasing the property, and wasn't that the goal? Wasn't that their agreement, to purchase the property?
If you go as far as believing that that expectation is an actionable expectation, and I believe the evidence is not clear on that, and I'm confident the evidence is not clear on that, as evidenced by the Meals Appeals Court's decision, they looked at the evidence and they said, this document, this March 98 agreement, says nothing about acquiring the property.
No,
of course, that's the goal to the whole enterprise.
Let me ask you this, I haven't laid out a chronology here, but it says that when did the consultant first had the negotiation with the Shelseys about the release of the secured debt?
Your Honor, I do not have that date at my fingertips, but I can tell you this. This was fast-moving. They bought the note on March 16th, 98, the same day they formed the agreement, the enterprise. By 2 months later, almost to the day, Premier had entered the agreement to acquire the property. This was a fast-moving activity on this property. So
that often is the case when somebody's in bankruptcy. And
correct.
That's when you move. You don't wait for 5 months. I take it there was no evidence that said we'd agreed on what an asking price was, we discussed it. As I understood, the instructions were to the consultant, go and get me the most amount of money that you can on this note.
The evidence is that the consultant came back and said, here's what the Shelseys are looking for. And that dollar value was too high. Pearson and Palm said, that is not a dollar amount we are willing to invest.
Fine, so you make a counteroffer. instead of which the consultant said, but I've got another way of doing this for you, where you'll make a quick turnaround. I'll try and sell you, I'll try and get them to pay you.
I would suggest, Your Honor, that that is a negotiation tactic that you've heard all the time. Buyers come in and say, nah, I really don't like this place, I'm not interested in it. If you approach the deal with too much eagerness, your price is going up.
But I take it you made that claim at trial, I assume.
I believe that was made, yes, Your Honor.
Right, so the jury could consider that
Correct.
and make a decision about that.
Correct. I'd like to, if I could, turn to the damages, because
Yeah,
I do think that, that one I think is even clearer of a basis for tipping this verdict, overturning this verdict. If you go back almost to the turn of the century, starting with the Hetherington case, moving forward to Lowry, moving forward to White Spot, and as recent as 2 months ago, Your Honors decided Twin Fires on the IPO stock sale. All of these cases state that you can't award speculative lost profits in this situation. If you find a breach, there are remedies that you have here. There are damages you can award, and there are ways that you can compensate for that breach. However, to allow the lost profits claim to go overturns all of that body of law that says, first of all, what damages are in the contemplation of the parties at the time they enter the arrangement. Second of all, what was the ability to prove damages with reasonable certainty as of the time of the breach?
Mr. King, let me ask you this. Mr. Notice O'Connor said O'Brien testified as to what he expected to make, no objection. Correct?
Your Honor, there were objections as to motions in limine to preclude the experts from testifying as
Not
to speculative damages.
O'Brien stands up and says, this is what I would have been able to make, or words to that effect. No objection.
Your Honor, I don't know if there's an objection to that specific statement on the witness stand, but I can tell you that the objections were made time and time again as to allowing the lost profits to go forward, and they were overruled, and the objections were reserved.
Let's take a look at those for a minute. All the local approvals had been obtained, had they not, to build the houses on these lots?
The local approvals were obtained. However, Mr. O'Brien needed to obtain additional permitting that was in his offer when he tried to buy the note himself, I might add, at a amount less favorable than the amount the Twin Hills was offering to buy it, the 400. His deal, his proposed acquisition was at a less favorable amount. He had a contingency there.
Assuming you could find that the lots were already locally approved to be buildable, then isn't it a very simple calculation where you get some evidence of, okay, we're going to build so many houses, we're going to sell them for so much, they're going to cost us so much to build, the profit's going to be this, and wasn't all that in there?
Respectfully, Your Honor, not at all. What happened here is the project that was ultimately built was very different from the project that Pearson, Palm, and O'Brien had envisioned. First of all, the house size was 500 square foot higher on the high end. The sale price was...
Oh, I understand that. So maybe you go back to what O'Brien said he would have done, right? I mean, in other words...
That would directly overrule your decisions in the White Spot case. That is this case. In White Spot, you had a ready, able, willing builder who was kicked off the job. The buyers had agreed to a price and said, yes, come on in and build it. They kicked him off the job. A different building was built, $20,000 more. And this court said, I'm sorry, that's speculative. You could not establish that that is the price that you would have gotten had you built it.
That's...
Lost profits are rejected in that situation. In the Lowry decision, Your Honors...
My issue goes to what was objected to and where. In other words, what could the jury have found, and what were the instructions to the jury? Was the instructions inaccurate?
Your Honor, the instructions were not inaccurate because they said, what damages do you find with reasonable certainty? And I submit to you that that implies and includes in it, embodies the case law that exists, and that is no speculative damages.
Well, did you ask for a specific jury instruction that was rejected?
No, Your Honor, because that is a proper statement of the law.
And the jury said and then there's evidence. I take it that evidence that was objected to was excluded, or you saved your objection.
Correct. Objections were reserved. It was not excluded. but the objections were reserved.
And to which particular evidence? The expert?
The expert who based his opinions of value on the project as completed 4 to 6 years later
Okay.
than the breach.
And any other objections?
The objections as to the whole line of lost profits were raised and reserved. The evidence came in. Now, you heard that Pearson and Palm put on evidence themselves as to costs because once it was coming in, they had to rebut what was going up on the boards. So, yes, they did put in their own evidence as to lost profit type damages because they had to rebut what was already going in.
Did the judge have before him the jet spray cooler case?
White spot? I'm
Yeah.
sorry. Yes, Your Honor, I believe it was in the briefs. It must.
And so, what was his reason for allowing the evidence in?
He believed, as he says in his dialogue from the bench, that as we've been instructed from the appeals courts, I'm going to let this come in, let the jury decide, and I can fix it after the fact if I think it's necessary.
Okay. Thank you, Mr. King.
Thank
We'll
you, Your
take
Honor.
a short break.